Welcome to All Things Social Security. My name is Stephanie Joy of Joy Disability. I am a Social Security disability attorney, and I would like to invite you to watch our daily video tips on the Social Security disability and SSI claims process each day at the new time of noon Eastern Standard Time here on YouTube on this channel. And on Wednesdays at 1 p.m. Eastern Standard Time, we have our live Q&A live stream. So you are welcome to join that as well. Ask your questions, get there on time, and you'll be one of the first answered. Thanks so much and have a great day. Enjoy the video.
Good morning, afternoon, or evening. I am giving a second shot at something we discussed, I don't know, maybe about a week ago. And it brought up some confusion on some people's parts, which is completely understandable. This is about the question of, pardon me, my phone. The fact that you can appeal a case and then withdraw your request to appeal it. All right, so let's say, and I'm going to give you an example of when this might be. You had a partially favorable award. You're not happy with not having a fully favorable award. This could mean that you asserted 3 years ago you became disabled, presented your evidence, you thought it was good and strong, and they gave you some other date, such as a change in birthday date, or based on a piece of evidence they say finally clinched it, whereas your original evidence early on did not. You might need some time. I mean, you get 60 days to appeal the partially favorable, which means you're appealing the whole thing and asking for a new resolution. It's got its risks. We discussed that elsewhere. That's not what this particular discussion is about. This is about the fact that you can file the appeal, say requesting an ALJ hearing. And if you then decide, you know what, I really don't want to take this risk. I got the partially favorable. It didn't give me the back benefits I wanted, but I got them going forward. And this whole process is really stressful, understandable. Plus, I got that added monkey wrench of that potentially remote risk, but a risk nonetheless that because they can look at the whole thing, that means they could decide that I wasn't disabled at all, that I didn't quite meet that middle threshold. So if you find that you are in that boat of should I, shouldn't I, and you haven't really had the time to decide, well, I can pinpoint the old date when they should have done it. I can really point out the evidence, and I think if I get it to a judge, he's going to see that. Plus, there might have been a missing piece of evidence that never got into the file because the doctor didn't respond to the SSA's request, or my lawyers or my own, and that piece of reporting that showed I had PT for that whole period, physical therapy, wasn't in there. I think I could potentially change it, but I really don't know. I'm afraid of the risk. You can appeal for an ALJ hearing. It's going to be a number of months before that hearing comes, and you get 75 days notice before any scheduled date. You could decide to make a request to withdraw your request for hearing with the ALJ, and invariably, I've never seen it not granted. I mean, we usually do a little blurb about it in the little form, but you can do that. So you can request that it be basically withdrawn, the whole, so that you're going to let the favorable award stand as it is. Okay. It could also be you didn't have a partially favorable award. You had a full denial, but you decided after learning a bit or whatnot that, I'm taking this denial to an ALJ, but the SSA is kind of right that I didn't even have treatment. I just started getting the treatment. I've had treatment for 6 weeks. There's a 12-month minimum duration. Maybe going to an ALJ hearing and getting a solid kanash on it 7 months from now is not in my best interest, because once you do that, now you have an ALJ denial. If you wanted to and could refile, you cannot assert, generally speaking, a date before the date of that judge's decision, which is right now 7 months in the future. Whereas if you start anew, you can actually kind of assert your old date and then get all your stuff in, ask for a reopen, and say, you didn't have this information, I want to reopen, instead of having it go to a judge. And they might just reopen it. If not, no harm, no foul. Now that you have 6 weeks worth, maybe they'll pull it back to 6 weeks, but you get another initial and another recon before you have to jump into a judge. And jumping into a judge with just a few months of evidence could be a good sign, could be a basis for a denial that you haven't even met the duration. right? I mean, doesn't mean you're going to get a denial, but I'm just saying you can, but in light of all that, you can appeal it to the ALJ, then decide to withdraw it. Gives you more time, more breathing time to decide. Not that the 60 days is too shabby, but sometimes, particularly when you're disabled, that time can go quickly in terms of you can't get it all together in time. And or you don't really know what you're looking at, you're trying to learn more. Maybe you're getting a consultation, asking for an opinion, what have you. So just something to think about. You can better to appeal it and then pull it back than to not appeal it. The 60 days runs, there is going to be no way you're going to get an out of time appeal for just cause unless you're like in the hospital for some extended period of time, by and large. So there are maybe rare occasions when you can almost, I think there's rare occasions where you can prove that you never received a denial letter. That's gonna be hard though, because if they produce a denial letter with a date on it, you might have a hard time proving that didn't go in the mail. The burden will be on you. So I say better to, in most cases, appeal it if you haven't had proper consultation or legal advice or whatever, and then decide whether you're going to keep that appeal going. But at least you protected your rights to that appeal from the judge. Okay. So I hope that kind of explains a little bit of that when I was saying, I can appeal and withdraw. So that's what that's all about. You can even do that at the lower levels. It's just that you don't have the same time frame awareness that you have with an ALJ. That stage is where you get the 75 days, you get the letter that says, and then here's the date, and the date is at least 75 days out. You have all that. So you have time to do things knowing when you're going to be cut off. Whereas initial and recon, they can deny you or award you. They're not going to tell you they're about to do it, denial or award. So, you can get a denial before you even expected it. Now you got initial denial. I mean, there's many ways to look at it, but it is definitely a safe thing to do, I have found, is to protect your rights to appeal. And then if you decide that's not what you really should have done, you rethought it, you can withdraw it. It's definitely permitted under the rules. All right. And I've never seen a judge say, no, I must insist on having this hearing, even though the claimant says he doesn't want it. So, all right. I hope that clears it up. Thanks, guys. Bye.